Imagine being branded a terrorist for supporting a cause you believe in. That's the reality facing supporters of Palestine Action after the UK government banned the group under terrorism laws. But here's the twist. The government's attempt to silence a legal challenge to this ban has just spectacularly failed. In a landmark ruling, the Court of Appeal has cleared the path for a full judicial review of the ban on Palestine Action, scheduled to be heard by a High Court judge next month. This decision throws a wrench into the government's plans and opens a new chapter in the fight over free speech and the right to protest. Let's rewind a bit. The co-founder of Palestine Action, Huda Ammori, had previously secured permission to challenge the Home Secretary's decision to proscribe the group. This legal challenge questions the very basis of the ban and its impact on civil liberties. The Home Office, while stating it would consider the ruling's implications, maintained that Palestine Action remains a banned organization, and its supporters will face the full force of the law. This ban, effective since July 5th, criminalizes membership or any form of support for the direct action group. Since the ban's implementation, over 2,100 individuals have been arrested during demonstrations. Some protesters have even been charged for displaying signs that read, "I oppose genocide, I support Palestine Action," potentially facing up to 6 months in jail. But here's where it gets controversial. Is supporting a political cause the same as supporting terrorism? This is precisely what the courts will be grappling with. The government's strategy was to block the judicial review, arguing that Parliament had already established a specific appeals process for challenging such bans. This process, outlined in terrorism laws, involves a de-proscription request submitted to the Home Office, followed by a potential review by the Proscribed Organization's Appeal Commission, a specialized court that often operates with a degree of secrecy. And this is the part most people miss. This entire process can take a year or more, effectively silencing any immediate challenge to the ban. Ammori's legal team argued that the unique circumstances surrounding Palestine Action's ban, coupled with the widespread public support the group enjoys, warranted a faster and more direct review by the High Court. They contended that Parliament didn't explicitly prohibit a quicker challenge, even though it had created the slower POAC route. The Lady Chief Justice Baroness Sue Carr sided with Ms. Ammori, stating that the de-proscription process and appeal to POAC weren't intended as the primary means of challenging the initial decision to ban a group. She emphasized that a judicial review would offer a quicker route to determine the lawfulness of the ban and provide authoritative guidance for criminal courts dealing with cases related to Palestine Action supporters. According to Baroness Carr, the judicial review would provide an authoritative judgment on whether or not it was lawful to proscribe Palestine Action, and this, crucially, could then be relied on in criminal courts hearing charges against any person arrested. A spokesperson reiterated the government's stance, claiming Palestine Action had engaged in an escalating campaign involving criminal damage, intimidation, alleged violence, and serious injuries, even targeting Britain's national security infrastructure. They emphasized that supporting Palestine and supporting a proscribed terrorist group are not the same thing. However, Ms. Ammori views the government's attempt to avoid judicial scrutiny as a major misstep, highlighting that the Court of Appeal's ruling allows her to challenge the ban on broader grounds than initially anticipated. She stated that they are heading into the judicial review in November with a stronger legal position, arguing that arresting peaceful protesters and those disrupting the arms trade is a dangerous misuse of counter-terrorism resources. Adding to her legal victory, Ms. Ammori also secured permission to expand the scope of her case in November, allowing her to present even more reasons to the High Court why the ban is unlawful. This victory significantly strengthens the challenge against the ban and raises fundamental questions about the balance between national security and freedom of expression. So, what do you think? Does the government have the right to ban a group like Palestine Action, even if its actions cause disruption or damage? Or does this ban represent an overreach of power that that stifles dissent and undermines the right to protest. Is it possible to support Palestinian rights without supporting potentially harmful actions? The comment section is open for your thoughts.